Hello, dear listeners. For this episode, I sat down with Professor Adrian Vermeule. Before we get to that episode, I want to apologize that there are some lags in the recording. We had some internet connection issues at various times throughout the episode. Professor Vermeule made no accusation, so I speak for myself, but I believe a clique of legal realists at Yale Law School sabotaged our internet connection to prevent the interview. They were largely unsuccessful, and we're getting the episode out. I am conducting an investigation and will report back in the future. In the meantime, here's the episode. Professor Adrian Vermeule is the Ralph S. Tyler, Jr. Professor of Constitutional Law at Harvard Law School. He serves on the Council of the Administrative Conference of the United States. He was elected to the American Academy of Arts and Sciences in 2012. He has written many books and articles, including Common Good Constitutionalism, Law's Abnegation from Law's Empire to the Administrative State, that's a title and a subtitle, and The Constitution of Risk. He joined me to talk about classical and administrative law. Hello, Professor. Thanks for joining us.
Hi, how are you? Nice to be here.
Great. This podcast will be about administrative law. However, I think it'd be useful for the audience to start with some constitutional law and talk about constitutional law and the classical legal framework, just to get those concepts on the table before we proceed to administrative law. So I'm hoping you can first just very quickly give an overview of the classical understanding of the legislative and executive power, and then we can treat the judicial power separately.
Okay, well, the classical view of constitutionalism is ends-oriented or teleological, rather than immediately jumping to institutional form. So one of the striking developments in liberal constitutional theory, and this is especially marked since World War II, is that people are obsessed with kind of institutional technologies. They're obsessed with what exactly are is the distribution of authority between institutions. Classical law doesn't start from that premise. It starts from the premise that the fundamental temporal end of government is orientation to the common good or general welfare. And that's, of course, laid out right at the beginning of our own Constitution. And then the classical perspective on law says that there are various ways to carry out a determinatio or institutional specification, so long as this fundamental end is retained. So that the classical law has always been more agnostic about institutional forms than is liberal democratic constitutionalism. So classical lawyers will say things like, and this is absolutely entry-level stuff for the classical lawyer, they'll say things like, a well-ordered polity can be a kind of democracy. They would call it politeia. It can be an aristocracy. It can be a monarchy, or best of all, for many classical lawyers, is a mixed form of government, which contains elements of all three of the baseline forms of government. If the polity is not well ordered, that is, if government is not pursuing the common good or general welfare, then we have degenerate forms of those possible regimes. So we have the degenerate form of monarchy is the tyranny of one man, the degenerate form of aristocracy is oligarchy, and the degenerate form of politeia, ruled by the many, is actually democracy, used in a somewhat different sense than today. So that's the baseline setup. And legislation as an institutional technology is actually, I mean, it's around in a certain form right from the beginning, but it doesn't become dominant until the 19th century and especially 20th century. So we need a bit of context to understand even the questions that we're posing when we talk about legislative and executive power. That said, I mean, the simple conception for the classical lawyer of the relationship between legislative, executive, and adjudicative power is that the legislature is the body that makes general rules for central cases, for ordinary cases. And then we have the application of those rules to particulars, both in the executive branch and in the judiciary. And those general rules have to be applied to particulars under the horizon of the fundamental aim of all law, which is that it's an ordination of reason to the common good. So that within classical law, both executive bodies and judicial bodies will sometimes have to adjust general rules to specific circumstances. And this is often called epikeia or equitas. And the idea is that, and this is a locution American lawyers used throughout the founding era in the 19th century, and it sounds strange to modern positivists. The locution is that a case might fall within the letter of the statute, but not within the statute itself. That's because the statute is taken to be a real thing that's rationally ordained for the common good, and that its text might imperfectly reflect that fundamental end. So we have famous problems like, I assume much of our audience may know the case Riggs versus Palmer, where there are general rules for making wills. And the question is, how those rules apply to a case where the heir has murdered the testator, his father, and so forth. And this is the point at which equitas or epikeia enters the picture. But I stress that in most ordinary cases, none of that is relevant. And in most ordinary cases, classical judges respect the text as an ordination of reason to the common good. It's just that they don't take the bare words of the text as definitional of law. They take the words of the text as an indicator of law.
That's a good transition point for me to talk about judiciaries and the judicial role. So you're saying in most cases, when you're judging in a classical legal system, it's going to look something like what we call textualism today. The philosophy behind it, if that's the right word for it, is different, though. Is that correct?
Yes, yes, exactly. So operationally, the classical judge will almost all the time look like an ordinary textualist judge, because most laws almost all the time work pretty straightforwardly for the central cases to which they were addressed. American lawyers today are somewhat obsessed with the idea of conflict of laws or hierarchy of laws. What do you do if equity is in conflict with the seeming apparent meaning of a positive text? That's not the way classical lawyers thought about law. They thought in terms mostly of harmonization of laws. So the fundamental structuring assumption is that because law is an ordinance of reason to the common good, we should be very reluctant to assume that it's in direct conflict with general background principles of law and of natural equity. So the work is mostly of harmonization of reading statutes to make the positive civil law, the natural law, the jus gentium or law of nations, and indeed divine law, to be kind of harmonized together in a coherent way.
That sounds a lot to me like the canon of constitutional avoidance. The judicial power is going to be reluctant to throw a wrench into the works when other branches of government have made this determination that something is in accord with the common good.
Yeah, I think that's right. And one has to understand the rich context of this in Western law. It goes back as far as the eye can see. So it goes back to the digest, which says that in all things, but especially in law, one interprets according to equity rather than the strict letter of the law. There's a constitution in the Codex that is the collection of enactments of Roman emperors as to law that says the same thing, that law should be interpreted according to equity. Now, of course, there are other texts in the Corpus Juris that may or may not be in tension with those, and a lot of the work of the glossators and then post-glossators is harmonizing all that. But the fundamental structuring presumption of the classical law runs like a golden thread throughout, I think, the history of Western law. So we have people like Baldus de Ubaldus saying that the emperor is always presumed to act in accordance with natural and divine law. So this is a kind of benign normative fiction that is used to harmonize, to civilize, to ameliorate, and to flesh out positive law.
Now that you've started talking about some sources, I wonder how we're supposed to use those sources as lawyers when we're doing that harmonizing. I don't take you to have ever said that, you know, if I have an ERISA case, for example, that I am going to go in and start quoting Thomas Aquinas in my 12b6 motion. The point of it is that you have a philosophical approach to the law that is different than your mainstream positivist textualist approach right now.
That's exactly right. I mean, exactly. So in 99% of cases that come before actual judges, there's no need to do anything highfalutin. When you have the ERISA case, you interpret it according to the ordinary meaning of words, and that's because unless your legislature is really dysfunctional in a tyrannical way, the ordinary meaning of words will, in all the central cases, track a rational ordination for the public welfare. So none of this is intended to say that judges or lawyers immediately start invoking equitas all over the place. The point is that there are two ways of putting the point. One is that there occasionally arise hard cases where positive law is ambiguous, indeterminate, it seems excessively general relative to the rational ends of law, or poses some other problem. And then this gives space for harmonization of the law with enduring background principles. The other way of understanding it, maybe conceptually more fundamental, is that the very meaning of law is always read against the horizon of normative understandings of what the legislative office is. And the legislative office is an office that is constituted for the public welfare. So we should very much hesitate to read the meaning of laws as though they are pursuing some other damaging end. Does that make any sense?
That makes a lot of sense, and I think that's we've covered some good ground there, and I think we can transition to classical law and administrative law. Okay, and we're back. I'm hoping you can start talking about the administrative state in classical law. We've talked a little bit about legislative powers, executive powers, and judicial powers. How does administrative law in this classical legal framework fit in?
So I think there are a bunch of converging ways to understand classical justifications for the administrative state. First, let me clear away one mistaken view that one often hears nowadays. It's become curiously prominent, and it's just wrong. This view holds that the American administrative state is a recent creation, or that the administrative state generally is a recent creation. Sometimes people say silly things like, well, Woodrow Wilson was the founder of the American administrative state. All that is wrong. So work by people like Jerry Mishaw and Julius Mortensen, drawing on work by historians of American constitutional development, have shown that the administrative state goes right back to the beginning, and that the very first Congress enacted broad delegations to the president and the executive branch for various purposes. And indeed, there's a body of work in sort of legal history and the development of legal institutions that shows that the administrative state goes much farther back than that. So it really has its origins in the Roman state, which then influences the Catholic Church, that brings the administrative state to a high pitch of sophistication, both institutionally and jurisprudentially. And then the Catholic Church in turn influences states of the kind of late Middle Ages and early modern period. So we have this famous treatment of Frederick II by Ernst Kantorowicz, who says that Frederick II's Liber Augustalis, or Constitutions of Melfi, is the birth certificate of the administrative state. And that's a law code that Frederick II promulgated for his Sicilian domains in 1231. Where does Frederick II get this kind of institutional technology? Well, he gets it from the Catholic Church. So I'm always a bit amused when I hear American Catholic legal scholars saying the administrative state is a creation of World War I or something. That's simply not the case. So that's a historical point I wanted to clear away. But I did want to give some classical justifications for the administrative state as well. But I don't want to go on too long.
I think that's good, because people might think of the administrative state as this very top-down thing. It's this thing that's imposed on people. And I think you have a different understanding of where the administrative state comes from in the classical understanding. Can you talk about that?
Yeah, absolutely. So let me say a few things. The simplest justification for the administrative state in classical legal theory is a kind of natural necessity. That is, the lawmaker can't specify all the detail of the law due to constraints of time and information. And I wanted to read you this quote that eerily anticipates the theory of delegation to the executive in modern administrative law. And the quote comes from Francisco Suarez, a great Jesuit theologian with legal interests, from his treatise De Legibus ac Deo Legislatoria in 1612. And here's what Suarez says about delegation. He says, there may be a delegation of power to frame a law decreeing whether or not it is just, useful, or necessary, and in what terms it shall be incorporated. But the power of the delegate does not extend to the ability to endow the law with binding force that's given by the delegating instrument. And he continues, in this sense, it is manifest that the power in question can be delegated, although in point of fact, this constitutes a delegation not of jurisdiction, simply of a form of ministry that requires knowledge and skill. Indeed, he says, it would hardly be possible otherwise for laws to be made by princes, since the latter could not accomplish unaided all that is necessary to the process of legislation. I mean, that's an absolutely standard justification for delegation that appears in all sorts of U.S. Supreme Court cases. It appears in Justice Scalia's famous defense of the Chevron doctrine, and it's as old as the hills. Another way of looking at the administrative state is the classical concept of determinatio, which is the concretization of the law at successive levels. So in the classical conception, the lawmaker has really two roles that are fused. One is the maker of law, but also the interpreter of higher law. So the French jurist Portalis, introducing the French Civil Code in 1801, said that human lawmakers are the respectful interpreters of background principles of natural equity. But the way they interpret natural equity is through determinatio, this concept, which is concretization of a general principle to a more specific form. So we might have a general principle that there should be statutes of limitations in some form. There should be repose for people who are under risk being sued. But obviously, the institutional and legal details of that require all sorts of further specification, and that's the function of the lawmaker. Then what the administrative state does is it carries out the process of determinatio to ever more specific levels. So the lawmaker enacts a general statute, as I said, and then we have executive agents who make it more and more concrete through rulemaking or adjudication. And this is what my colleagues Jack Goldsmith and John Manning called the completion power. And this is absolutely the classical conception of one dimension of executive action, which is that it gives more and more concrete specification to general legislative rules that are necessarily, by the nature of things, not fully determinate. And Chevron is just agencies adding concretization, and maybe later we can talk about how deference naturally falls out of that picture. A third point I wanted to make about this, and maybe this is closer to your interests, is that there is in the classical law a fundamental normative justification for the administrative state apart from natural necessity. And the fundamental normative justification for the administrative state is that a sovereign people, initially the Roman people, but all sorts of sovereign peoples in other later polities, may empower an executive and a bureaucracy precisely to preserve their sovereignty and to protect them from the depredations of the few. Let me just give 2 moments in this, one very old and one very recent in historical perspective. A very old one is Pomponius's summary at the beginning of the digest of the development of Roman legal institutions. And Pomponius says, look, the Roman people, under pressure of circumstances, realized first that it was hard for the entire citizenry to assemble and direct democracy. So the necessity of the case imposed upon the Senate trusteeship of the Commonwealth. This is like setting up a Congress because you can't vote on everything directly. And then at a subsequent stage, it turned out that the senatorial elites, according to Pomponius, were unable to govern all the provinces honestly. And in this second best non-ideal circumstance, the Roman people effected a transition of law to the executive, in their case to a kind of quasi-elected, quasi-selected imperial office. And you can see the point here is that people are empowering the executive as a way of defending themselves against bad government by political and legal elites. And this is, ironically, very, very much James Landis's fundamental justification for the administrative state in the New Deal. So Landis says that the problem in our day isn't senatorial elites, it's quasi-private actors like corporations that, according to Landis, are exercising a kind of sovereignty, and that in order to protect popular sovereignty, the American people have, over time, through their representative institutions, created and empowered an executive branch, presidency, and agencies that protect them from this kind of collection of quasi-sovereigns. So this is an ancient theme and a modern theme in the classical law, and it's a fundamental justification for the administrative state. And it has the feature that the administrative state on this view is not founded in expertise, although that is separately a question we can discuss. But what it's founded in is precisely the desire to translate or preserve popular sovereignty in a changing, non-ideal world. So it's a mistake on this view to see the administrative state as a hostile opponent of popular sovereignty. It's a creation of popular sovereignty. And indeed, the administrative state does not fall out of the sky or fall from the pen of Woodrow Wilson. It comes from decades and indeed centuries of enactments by Congress that have deliberately created agencies and empowered the president in all sorts of ways in order to achieve aims that Congress, as representative of the people, felt were beneficial to the public interest. So the administrative state can be seen as a means of popular self-defense in a certain way. And the final point I wanted to make about the connection between the modern administrative state and the classical law is a very interesting observation by a guy named Herbert Felix Jolowitz, who was the Regius Professor of Civil Law at Oxford in the 1950s, a great Roman lawyer. And he made an observation about modern programs in the administrative state, things like social insurance, sorts of public regarding creations of programs that are supposed to help people live better. And he said that these kinds of programs were more reminiscent of the classical approach to law than was the 19th or late 19th century conception of law simply as negative prohibitions that create rules of the road. So Jolowitz said that the classical view of law was that it's fundamentally positive, that government creates positive programs for the general welfare, and that we have kind of in some way rediscovered that in the administrative state. So I think we have there maybe four converging classically themed justifications.
That makes a lot of sense. I think a skeptic might be a little bit worried and say, okay, you have these justifications for the administrative state, but how do we, if law is an ordinance of reason, how do we make sure that this big thing that we've created is using reason? Is there anything that the classical law says about that?
Yeah, absolutely. So, I mean, let me start out with some points that should be obvious. Is that we have to avoid nirvana fallacies. That is, we don't want to compare an ideal case of a non-administrative state with a abusive, dysfunctional administrative state. That's not a coherent comparison. No human form of government is going to be perfect, but in many cases we are choosing a kind of lesser evil. And Pomponius's argument for the delegation of the power of the Roman people to the executive very much takes that form. It's that the alternative is worse. The alternative of dishonest government by the optimates. That's point one. The point two, however, is that, and I think this returns a bit to some earlier themes that I mentioned, is the classical law picture of law treats law as under a kind of benign normative presumption or assumption that it can be interpreted in public regarding ways and harmonized with enduring background principles of natural right and natural equity. So that if it's true that the emperor is always presumed to honor natural and divine law, so too any executive officer in their action is presumed to honor enduring background principles of equity, and that this is the ordinary way that statutes, regulations, agency action gets interpreted in the administrative state. And indeed, as a matter of black letter administrative law and American administrative law, the Chevron doctrine kind of gives way, or more accurately, is harmonized with traditional canons of construction. So, for example, um, agency delegations to agencies are presumed not to violate the Constitution unless it's indisputably clear otherwise, or they're presumed not to authorize retroactive rulemaking unless it's clear otherwise, and so forth and so on. So the classical law brings to bear its ordinary tools of harmonization and the assumption that different principles and levels of law are coherent in order to try to help ensure that the administrative state is ordered to the common good.
That's great, and that's helpful. And I think with that background, we can transition to focusing more so on the United States. I'm just going to try to provide a little background for our non-lawyer or international listeners on how administrative law works in the United States. This is basically trying to condense an entire law school course into about 30 seconds, but I'm going to try it anyway. In the United States, basically what happens is Congress passes laws with relatively general wording. That wording will empower or command an agency to do something. I think a famous example is in Whitman, where the Clean Air Act required the EPA administrator to promulgate air standards, among other things that are requisite to protect the public health. The Supreme Court has said that these broad authorizations do not violate Article 1, that's where Congress is, the vesting clause in Article 1, so long as they provide an intelligible principle, and basically the court never strikes down laws based on the intelligible principle test. The matter doesn't really end there, though, because there are a lot of judicially crafted doctrines and the Administrative Procedure Act, which govern agency action. So, for example, agencies will engage in rulemaking or adjudication, and Article 3 courts will review those actions based on different standards. These standards are usually fairly deferential, and they are oftentimes more oriented towards the decision-making process that the agency undertook rather than the substance or the policy outcome that the agency got to. One type of deference to know about is Chevron deference, which basically says that courts will defer to agency interpretations of statutes so long as those interpretations are reasonable. There are other similar types of deferences, like our deference, which is about interpretations of agency rules. Courts say that Chevron deference is a two-step process, but they are just trying to make their jobs look harder, and there's really just one step. Sorry, that last part was a joke. If you didn't get it, just disregard. Anyway, with that background in mind, we've touched on this a little bit. Is it fair to say that the United States has a popular sovereignty basis for its administrative state?
Yes, absolutely. So, not to refer to my own work, but I have a earlier book, Law's Abnegation, that takes on the claim that the administrative state is an abdication of legislative power and an abdication of popular sovereignty. And the argument there is that the administrative state is fashioned deliberately over time by our representative lawmaking institutions. So it is a sustained, deliberate, reasoned creation by Congress in response to various popular demands, popular outcries for protection against social, economic, and legal evils. And it's best seen as an expression or a means of popular sovereignty rather than an abdication of popular sovereignty. And in this way, when Congress delegates to the president and to agencies the power to this completion power to fill in the details or interstices of general norms through rulemaking and adjudication, we have a concretization of a purpose that ultimately stems through their representative institutions from the American people. So one of the myths I want to combat is this idea that the administrative state is a kind of alien occupying power. It's rarely put in such lurid terms, but that's very much the background music of many critiques of the administrative state. Quite the contrary, it's an expression of the needs, desires, hopes, and will of the American people over time. One way I think to recalibrate one's intuitions, for example, is to go back and look at the 19th century origins of uh, some of our leading administrative agencies. So, food regulation does not come about because of an abdication of legislative power or because of um, some sort of rent seeking by nefarious forces. It comes about because, to a surprising degree, people are often dying in awful ways from unregulated food. There's a amusing little strain of literature about breakfast cereals and their toxicity before uh, before national food regulation is initiated. So these things um, come about often because there's a genuine, widespread social economic problem to which the people, in some broad sense, want a response and from which they want protection.
I think one of the concerns, at least on the American right, is that this administrative state becomes a fourth branch of government that the president cannot control.
So I think there's a good point actually here, and this is where I find some common ground with these critics. Although I think that they often mix up two different things. The two different things that they mix up are delegation to the executive, uh, sort of um, generally speaking, on the one hand, and the role of independent agencies on the other hand. So sometimes the administrative state is used in some broad way to refer to the executive branch generally. Sometimes it's used more narrowly to refer to independent agencies not fully subject to presidential control. And sometimes people skip back and forth between those two senses, even in the very same article or the same conversation. And here, I think that the right view of the executive state, if you like, generally, is the one set out in the Myers decision in the 1920s, that all executive branch officers, when they exercise power, are exercising the president's power. They are as though contained within the president's office, and therefore, I applaud and approve of the recent course of Supreme Court decisions that have sharply restricted the authority of independent agencies relative to the president and sharply expanded the removability of subordinate executive agents by the president. But that debate gets mixed up with the larger non-delegation debate. And sometimes critics of independent agencies think that opposing all delegation is part and parcel of their view. Well, it's not. So delegation to the president is the chief executive of the the head of the administrative state is very much in accordance with popular sovereignty, and it's a separate question whether there should be executive branch officers who are independent of the president, if that makes any sense.
That makes a lot of sense, and I think it is important clarification. Um, I think with that, we can start talking about some nuts and bolts of administrative law. How how is rulemaking and adjudication in administrative agencies sort of attuned to these classical principles of administrative law?
A few things to say here. One is that statutes all the time will give administrative agencies an analog of classical imperium. That is, in its developed form, imperium just means the power to make legal rules or take legal decisions in the public interest. And delegating statutes in the administrative state constantly, routinely give agencies the authority to regulate in the public interest. But as Justice Scalia observed in a famous concurring opinion in a case called Webster versus Doe, the flip side of that is that statutes are always interpreted to require agencies to act in the public interest rather than in some other interest. So it is, according to Scalia, and I think he's very much channeling the classical view here, it's always implicit in statutes that an agency may not take public action to benefit some private constituent or to give a job to someone's nephew or for corrupt purposes and so forth and so on. So that's all one point. Another point is that the structure of rulemaking builds in the kind of popular consultation that is very much a feature of the classical theory of mixed government. So if you go back and look at Aquinas, for example, at one point he praises mixed government and says that what it allows is taking into account popular views in a process of the formulation of law. And the notice and comment process for rulemaking is calculated to do exactly that. Now, we can have a separate conversation about how well it works and so forth, but that's the theory of the institutional structure. The third point, of course, is that all administrative rulemaking is subject, or approximately all, is subject to arbitrary and capricious review. And the whole point of arbitrary and capricious review is to ensure that agencies act in reasoned ways. So in my most recent book on common good constitutionalism, I say that arbitrary and capricious review is indeed a kind of model for the classical approach to judicial review generally. The point of it is not so much to police agency rulemaking according to the kind of meaning of the relevant text. It's to ensure that the agency is acting for the right ends through reasoned ways. So it's a kind of means and review that sees reasoned decision making as the fundamental constraint on means agencies may use. So in all these ways, both with respect to the definition of ends that agencies can pursue, with respect to the processes, consultative processes by which they pursue them, and finally, with respect to the fundamental requirement of reasoned decision-making, agency rulemaking process has a lot of surprisingly classical features. And indeed, I think, as I argued in a piece called The Original Scalia, indeed, I think that's why Justice Scalia, who through most of his career was a great champion of the administrative state, this is why he liked agency rulemaking or thought it was generally in the public interest.
That makes a lot of sense, and it pairs nicely with Chevron and the other related deference doctrines that courts have developed. We've talked a little bit about Chevron. already, but you see Chevron basically as part and parcel with this classical legal tradition where the court is basically saying another actor is acting in the common good. So therefore, as long as that looks reasonable, then they get deference. Would that be accurate?
Yeah, so I think the right way to understand Chevron from a classical legal perspective is as I said, as determinatio. It's just as the legislature engages in determinatio of background principles of the common good and natural equity. So too, then an agency comes along and engages in determinatio of the legislature's general instruction. So it completes the legislative purpose and adapts it to particular subcases that may present different features. And a lot of rulemaking and adjudication is agencies saying, well, the legislature's given us general instruction like regulate chemicals that pose an unreasonable risk. What we have to do is identify subclasses of chemicals that do and other classes of chemicals that don't, and so forth. And then adjudication applies the agency's rules even more concretely to particular cases. And all this happens, as you said, under this horizon of reasonableness. So the classical law doesn't see lawmaking as a kind of antagonistic process. It sees it as a process of successive specification in the name of the common good. So successive adding of content by various actors at different levels. So it sees it as fundamentally, in some way, cooperative rather than prohibitive. And that's the very much the mindset behind Chevron. I think deference falls naturally out of that. So if Chevron is a form of determinatio, well, the whole theory of determinatio is that when you have a general either background principle or a general instruction from a legislature, there may be multiple ways to carry out that instruction that are all reasoned. So Aquinas' example is we give someone a commission to build let's say, a hospital for our city. The purpose of the commission constrains the ways they can do that. There are some ways to build a hospital that will be simply dysfunctional, but there may be more than one way to build a hospital that will be functional. And we defer to the specification of the general instruction in the sense that if the agent is carrying out their task of completion of specification in good faith, we give them leeway to judge primary judgments on the scene about what is the best way to do that in the circumstances. And that's the simple intuition behind Chevron, that if Congress says regulate chemicals that pose an unreasonable risk, we're then faced with two choices. One is the judges, quote unquote, de novo, who can try to decide for themselves what counts as an unreasonable risk. But that seems distinctly unpromising. Or, and this is by and large the approach modern American administrative law has taken, the judges can say to the agency, you make a primary judgment about what counts as unreasonable risk. We will review that judgment for a kind of good faith and a kind of rationality to make sure that you have stayed within the bounds of the mission Congress has given you. But we will not ourselves try to make a primary judgment about what unreasonable risk of injury means, especially with respect to a complicated subject. So I don't think Chevron rests on some fancy, complicated intuition. It's just a way of respecting the leeway that primary agents are given to flesh out congressional instructions.
That's good, and that makes a lot of sense. A skeptic might say, we sort of fought this twofold revolution, first against the Stuarts and then against King George, aren't we? Don't we have a strict separation of powers? Maybe not total separation of powers. I think everyone recognizes that. For example, there's the veto power, but we have a strict separation of powers. That's what our Constitution is supposed to be. And aren't we sort of blending powers here?
Okay. First, as a matter of background, about the kind of fundamental aims of the American Revolution. Second, about originalism in the classical legal tradition. And third, about the separation of powers in particular. It's funny that I mean, it's great, but it's also interesting to me that you mentioned the Stuarts because returning to Landis, his analogy between his claim about modern corporate power, this quasi-private power that actually arises from public legal decisions like corporate charters. Landis compared these gigantic corporations to the Stuarts. And he said that the problem with these gigantic corporations is they exercise a kind of unchecked power through law that is reminiscent of the Stuarts. And that in order to precisely to carry out the fundamental aim of the American Revolution, which is to create and protect popular sovereignty, the administrative state was necessary because the alternative was a world of private sovereigns exercising a kind of tyrannical power. So, on that high level of generality, Landis saw the administrative state not as in opposition to the throwing off of monarchy, but as a necessary concomitant to the throwing off of monarchy. It's a way under changed circumstances of completing and translating the purposes of the American Revolution. That's point one. Point two is we have to be very careful when we discuss originalism not to accept the label at face value. I don't want to rehash the arguments of my book and the very striking and enormous subsequent debate it provoked. But I'll just say that in my view, the framers were themselves classical lawyers. They thought in classical legal categories rather than modern positivist categories. They themselves weren't originalists, so that originalism has a self-defeating quality. If we think ourselves back into the legal cosmology of the framers, it's a classical legal cosmology, which sees the law as partly use civile or positive law, it's partly natural law, it's partly use sentience, it's partly divine law. So the categories are the classical legal categories. Now let me get to the separation of powers in particular. The theory of Chevron, of course, is that it is not only consistent with the separation of powers, but it's a corollary of the separation of powers. So when Congress creates a delegating instrument, it gives the president and subordinate agencies authority to execute the laws. And that execution of the laws, so long as it stays within the constraints that we've discussed at some length, isn't a usurpation of legislative power. It's carrying out of the office that the Constitution gives to the president and then through the president to subordinate agencies. So that's why Justice Scalia wrote in a case called City of Arlington that when agencies make rules or adjudicate, the theory of our law is that they are engaged in an exercise of executive power rather than some other kind of power. So that the opposition between Chevron on the one hand and the separation of powers on the other hand is a chimera. Now, one thing that one hears is that judges have to engage in quote unquote de novo independent interpretation of statutes and that that's a requirement of the separation of powers. I somewhat despair when I hear this because as long ago as 1983, just before Chevron was decided, a legal scholar named Henry Monahan, in a article that should be better known today called Marbury and the Administrative State, pointed out the, I think, simple fallacy in this view. Monahan's point, and I'm going to somewhat paraphrase it, is that it is a mistake. It's a conceptual error to contrast de novo interpretation with deference to agencies. The judicial role, of course, is to construe the statute to understand the scope and purposes and ends of the relevant delegation from Congress. We can call that de novo if we like. But then deference falls out of that on exactly the classical premises I mentioned, because the judges try to ascertain whether the agency has faithfully and reasonably carried out the purpose that Congress has entrusted to it. And doing that is precisely a way of respecting the independent judicial authority to say what the law is. And it's precisely a way of respecting the separation of powers rather than a contravention of the separation of powers. So one of the worst, I think, conceptual mistakes in this whole debate is to contrast de novo interpretation with deferential interpretation. De novo interpretation is what yields deference on Monahan's view, and I think that's very clearly the theory of Chevron.
I want to pick that back up in a second, but first I want to just ask you very open-endedly, what do you think of the major questions doctrine?
Well, there's so much to say about this. I think first that people have misunderstood the roots of the major question doctrine. So why do we see it suddenly appear in the past 2 decades or so? People see it as an opponent of Chevron, and there's a sense in which that's true. But ironically, I would suggest that the major questions doctrine and Chevron spring from exactly the same root cause. And the root cause is, imagine you're a judge on the DC Circuit. And to use the example that I keep using, you have a statute before you that delegates to an agency the power to regulate chemicals that pose, quote, unreasonable risks of injury, unquote. You as a judge have every reason to think, and I think you are quite right in thinking this, that for you to engage in quote unquote de novo interpretation of what counts as an unreasonable risk of chemical injury will be a disastrous enterprise. Like nothing in your legal training, nothing in your legal background equips you to decide what counts as an unreasonable risk of chemical injury. And Chevron and the major questions doctrine are both in different ways responses to this. Chevron says, let the agency decide, subject to all the constraints of reasoned decision making that we've discussed. Let the agency decide what counts as an unreasonable risk of injury. The major questions doctrine says, well, could we have a clearer statement from Congress about what counts as an unreasonable risk of injury? Both are ways for judges to avoid actually de novo interpretation of a statutory text that they think is in some fundamental way outside the bounds of their office and outside the bounds of their training. So Chevron and the major questions doctrine spring from the same root rather than being antagonistic, and that's one of the great ironies of this debate. The other thing I'd say about the major questions doctrine is that it represents a kind of fictional attribution of meta intention to Congress in exactly the same way Scalia said Chevron does. So Chevron rests on the attribution of intention to Congress, that agencies can engage in determinatio of or specification of incomplete or general statutory provisions. The major questions doctrine rests on an attribution of a general meta intent to Congress, that when questions are of great economic, political significance, that Congress would not want agencies to be able to do that. So they have exactly the same methodological status, and people who try to say that Chevron is in some way methodologically objectionable in a way that the major questions doctrine doesn't, are, I don't think are understanding the two approaches correctly. Which approach, to me, is a better attribution of meta intention to Congress? Well, clearly Chevron is. The people have done work on this recently, and there's work forthcoming, but there's no general reason to think that Congress only wants agencies to be able to decide under Chevron horizon kind of relatively unimportant or minor policy questions. Indeed, there's good reason to think that the more important the policy question, the more likely it is that Congress, aware of its own limitations, aware of the limitations of its knowledge and foresight, aware of the possibility of changing circumstances, will delegate more broadly agencies. So, as a general meta canon of construction, I think the major questions doctrine simply has no basis in fact. So, yeah, I think it's an ironic attempt to avoid de novo interpretation that doesn't have much to recommend it as a canon.
The Supreme Court is going to hear a case next year, or next term, I should say, on Chevron. I'm wondering what you think happens if they overrule Chevron.
Yeah, so much to say here. One is it is very ill defined what overruling Chevron would even mean, and that's for the following reason. Chevron contains this famous two-step test, but the fundamental Chevron principle of deference to reasonable agency interpretations is far older than Chevron itself. Ron Levin traced it back as far as an opinion by Chief Justice Marshall in 1809, if I remember correctly, called Vowell, where Chief Justice Marshall said that in doubtful cases, we would defer to a longstanding construction by the executive department. And there's a kind of grimly hilarious, from the current standpoint, document in 1928. It's a lawyer's edition annotation that contains hundreds of such deference cases stretching back to the foundation of the Republic. By the way, one thing you will hear in these debates is that all the deference cases of either the 19th century or at least before the enactment of the APA were mandamus cases. That's simply not true. So the Vowell decision that I mentioned from 1809-ish is not a mandamus decision. It's a direct action. And there are a number of cases like that from the founding era onwards. So overruling Chevron is not a simple, well-defined idea. The question is, how much do you have to overrule? At a minimum, you'd have to overrule maybe a dozen cases before Chevron, stretching back to the famous Hearst decision in 1944, which said that when agency interpretations have a reasonable basis in the law, they are controlling because Congress is delegated to the agency as incident to its execution of the statute, the power to interpret the statute. So first point is overruling Chevron is not a simple or well-defined idea. Second point is, and this is the force of the Moynihan logic that I mentioned earlier, is that it's perfectly possible to say what we do in Article 3 is de novo interpretation, and then recreate, if you like, Chevron deference as a corollary or consequence of de novo interpretation. So when people fall into this confusion and they think that de novo interpretation is contrary to deference, it raises the specter that the court may nominally overrule Chevron, but then recreate deference just in the guise of de novo interpretation of the scope and aims of the delegation. The third point I want to make is that even if Chevron were, in some sense, nominally overruled, I think that deference would continue in a more or less tacit form. I do not believe that DC Circuit judges are going to try to decide for themselves what counts as an unreasonable risk of chemical injury. I think that they will end up, whether in through the Monahan logic or simply in a tacit, non-transparent form, they will end up deferring to agencies about what that sort of thing means. So I think that a lot of the debate over this case Loper Bright proceeds on false premises. I also think that when the Supreme Court actually comes down to it, they may get a bit nervous about overruling Chevron. We saw exactly this pattern with respect to the Kaiser decision that surprised many conservative legal scholars and many libertarian legal scholars because there was a great deal of hope in certain quarters that the doctrine of our deference to agency interpretations of their own rules would be overruled. And then the court, in a certain way, flinched, and you had a plurality opinion with some funny concurrences that ended up more or less reaffirming our deference, although emphasizing the constraints surrounding it. Why did the court flinch in Kaiser? I think it's because all the excitement about abstract theory gave way to the realization, the very practical realization, that overruling our deference would put courts in the intolerable position of doing de novo interpretation of very complex agency rules with respect to the sorts of problems that I've been mentioning all along. And it is not impossible to me to imagine a similar process happening with Loper Bright. That is, the Loper Bright case has a slightly non-standard, funny fact pattern under a statute few people have ever heard of. But when the justices focus on the issue that the case presents, and focus on the problem of interpreting de novo, unreasonable risk of chemical injury, I think that it's very possible that they may decide that some form of deference has to be retained, perhaps through the Monahan rationale. So this is always the stage at which everybody expects a dramatic overruling, but often when we get down to the actual concrete problem, things don't pan out as people expect.
It's all very interesting and gives us a lot to think about heading into next term. So we'll be looking at that case pretty hard. You've been very generous with your time. I'm wondering if you just have anything that you're working on that you'd like to tell the audience about that's coming out.
Yeah. Well, some of this discussion has been based on a paper of mine called "The Many and the Few" about classical justifications for the administrative state that's available on SSRN. I think some of that work and some joint work I've done with Professor Connor Casey from Surrey, we are thinking about expanding into a book. And the book will it'll make a few fundamental points. One of them being that the administrative state is as old as Western law and is important ways of creation of the Catholic Church in particular. And another point is that American legal conservatives in particular should understand that the administrative state can be purposed to public regarding ends. That is, there is absolutely no reason that we can't have um, uh, agencies and other executive branch bodies promoting things like traditional families, promoting other aspects of the natural law through executive branch activity, rulemaking, and adjudication, so that there is a kind of floating assumption out there among American legal conservatives that the administrative state is necessarily a hostile force. And one idea of this book would be to say that that's simply not so.
Great. That's awesome. And we'll look for those items. Thank you so much for your time and have a nice day.
Okay, thank you so much, Joseph.